California Civil Procedure Handbook Rules, Selected Statutes and Cases and Comparative Analysis, Chapter 9, Subpart B, Time Limit for Appeals. 2. General time limits. Wonder what happened to 1. Rules 8.104A through F of the California Rules of Court set forth the general time limitations for civil appeals from Superior Court. A. Normal time. Unless the statute or Rule 8.108 provides otherwise, a notice of appeal must be filed on or before the earliest of 60 days after the Superior Court clerk mails the party filing the notice of appeal a document entitled Notice of Entry of Judgment, or a file stamped copy of the judgment showing the date either was mailed to 60 days after the party filing the notice of appeal serves or is served by a party with a document entitled Notice of Entry of Judgment, or a file stamped copy of the judgment accompanied by proof of service, or 3. 180 days after entry of judgment. B. No extension of time, late notice of appeal. If a notice of appeal is filed late, the reviewing court must dismiss the appeal. E. So we go to ... We go from B to E. Premature notice of appeal. A notice of appeal filed after judgment is rendered but before it is entered is valid and is treated as filed immediately after entry of judgment. 2. The reviewing court may treat a notice of appeal filed before the Superior Court has announced its intended ruling, but before it has rendered judgment, as filed immediately after entry of judgment. F. Appealable order as used in subdivision A. Judgment includes an appealable order if appeal is from an appealable order. In the usual civil case where a party serves the notice of entry of judgment, Rule 8.104A2 provides the relevant time limitation. Rule 8.104A1 is more likely to apply in the dissolution of marriage cases where Superior Court clerks are required to mail the notice of entry. See CCP 664.5, Rule 5.134, California Rule of Court Rule 8.104D contains specific definitions what constitutes entry of judgment or appealable order based on the procedure followed by the trial court and should be read closely. Late appeals. The time for taking an appeal is mandatory. An appellate court has no jurisdiction to consider an appeal taken after the applicable limitation period has expired. Rule 8.14C, C# versus Union Pacific Railroad Co. of 1992. Neither mistake, inadvertence, accident, misfortune, estoppel, nor waiver can afford relief from the jurisdictional necessity of filing a timely notice of appeal. Delmonico versus Laidlaw Waste Systems, Inc. 1992. Appeal untimely when not filed within 60 days after service of notice of entry of judgment pursuant to Rule 8.104A2. Despite fact that notice stated incorrectly date of entry of judgment, the time limits for filing a notice of appeal set forth 8.104A must be closely observed and will only be extended as provided by Rule 8.108 or an applicable statute. Extensions for post-judgment motions. Rule 8.108 provides extensions for time in which to file a notice of appeal when a party challenges judgment by filing a notice of intention to move for a new trial or to vacate a judgment, moves for a judgment notwithstanding the verdict, or moves to reconsider an appealable order. Revised Rule 8.108 must be read closely to determine the various circumstances in which the time to appeal is increased due to the filing of certain post-judgment motions. Cross appeals. The first appeal filed in a case is the appeal. Any subsequent appeals by any party are cross appeals. See Rule 8.108E. California Rules of Court Rule 8.108E, which deals with Cross appeals provides as follows. If an appellant timely appeals from a judgment or appealable order, the time for any other party to appeal from the same judgment or order is extended until 20 days after the Superior Court clerk mails notification of the first appeal. 2. If an appellant timely appeals from an order granting a motion for new trial, an order granting within 150 days after entry of judgment, a motion to vacate the judgment or a judgment notwithstanding the verdict, the time for any other party to appeal from the original judgment or from an order denying a motion for judgment notwithstanding the verdict is extended until 20 days after the clerk mails notification of the first appeal. 3. Preserving error for appeal. The appellant has the responsibility for preserving an error for appeal by making necessary objections or taking other appropriate actions during the trial court proceedings. Generally, an issue must be raised in the trial court to be argued on appeal. See example, North Coast Business Park v. Nielsen Construction Company, 1993. Likewise, the theory upon which a case is tried must be adhered to on appeal. Ernst v. Cyril, Frink v. Prod. One major but ill-defined exception is that issues of law or new legal theories based on undisputed facts may be raised for the first time on appeal. For example, Ward v. Taggart, 1959. Although facts pled and proved by plaintiff do not sustain a judgment on the theory of tort advanced in the trial court, they are sufficient under the quasi-contract unjust enrichment theory advanced on appeal. Fisher v. City of Berkeley, 1984. Supreme Court considers antitrust issues with respect to validity of rent control ordinance, even though raised for the first time on appeal, because based on undisputed facts and involves question of great public importance. Not only must an issue be raised in the trial court, but error must be preserved for appellate review by an appropriate challenge during the trial proceedings. Dewars v. Golden Gate Bridge District, 1979. Appellate courts will not consider procedural errors where an objection could have been but was not presented to the lower court, or where acquiescence constitutes waiver or estoppel. Failure to register a timely objection in the proper manner generally waives the issue for appeal. CCP 353A. No appellate consideration of erroneous admission of evidence unless record contains objection with specific grounds. But see example CCP 647, list of trial court orders to which exception is deemed to be made. Myers Building Industries Ltd. v. Interface Technology Inc. 1993. The court raises issue regarding special verdicts on its own motion because the due process consideration, despite lack of objection. All right, let's just read that one more time. The court raises issue regarding special verdicts on its own motion because due process considerations, despite lack of objection. Consolidated Theaters Inc. v. Theatrical Stage Employees Union of 1968. A failure to object to subject matter jurisdiction in the trial court does not preclude raising it for the first time on appeal. Okay. Some trial errors require additional procedural steps, such as a motion to strike, to reserve them for appeal. For example, Sabella v. Southern Pac of 1969. The party must both object and request that jury be admonished to preserve for appeal issues of attorney misconduct during closing argument. CCP 657-5. Claim of excessive or inadequate damages cannot be reviewed on appeal unless first urged as error in a timely motion for new trial. CCP 437B, C, B, and D. Objections to form the end competency of declarations and other evidentiary objections deemed waived unless made at summary judgment hearing. Standards of appellate review. The term appellate standard of review refers to the degree of deference an appellate court must grant a particular type of trial court ruling. Generally, an appellate court must apply one of three available standards of review in assessing the correctness of the trial court determination: the substantial evidence rule, independent de novo review, and abuse of discretion. Substantial evidence rule. An appellate court must apply the substantial evidence rule when reviewing a trial court's determination of an issue of fact, whether in a jury or non-jury trial, based on whether there was sufficient evidence to support the determination. Example, Alderson v. Alderson of 1986, Tillery v. Richland of 1984. This standard is usually stated as follows. In reviewing the evidence on appeal, all conflicts must be resolved in favor of the respondent, and all legitimate and reasonable inferences indulged in to uphold the verdict if possible. It is an elementary but often overlooked principle of law that when a verdict is attacked as being unsupported, the power of an appellate court begins and ends with determination as to whether there is any substantial evidence, contradicted or uncontradicted, which will support the conclusion reached by the jury. When two or more inferences can be reasonably deduced from facts, the reviewing court is without power to substitute its deduction for those of the trial court. From Crawford v. Southern Pacific Company of 1935. Independent de novo review. An appellate court gives no deference to a trial court's determination of a pure question of law, but must engage in an independent de novo review of the issue. See example, Parsons v. Bristol Development Co., Stratton v. First National Life Insurance Co. of 1989. What constitutes a pure question of law? How can an appellant persuade the reviewing court that an issue is one of law as opposed to one of facts? What factors will the court consider in making this distinction? Why is it important for an appellant to have an appellate court characterize an issue as one of law? Because there's more likelihood that the appeal court can review it. That it passes the standard of review to enter the appeal court. Abuse of discretion. Abuse of discretion, a wide variety of decisions are by law committed to the discretion of the trial court. The appropriate standard of appellate review of such decisions is abuse of discretion. What precisely does this standard mean? A typical general definition was stated in Shamblin v. Brattain of 1988. The appropriate test of abuse of discretion is whether the trial court extended the bounds of reason. When two or more inferences can reasonably be deduced from the facts, the reviewing court has no authority to substitute its decision that the trial court for that of the trial court. The abuse of discretion standard may overlap with the other appellate standards of review. Why? In making a discretionary decision, a trial court must apply the correct legal standards and follow the proper procedures. See Dockery v. Hyatt of 1985, Bartling v. Glendale at Adventist Medical Center of 1986. The factual basis for the trial court's exercise of discretion must be supported by substantial evidence. See Westside Community for Independent Living, Inc. v. Opolito of 1983. Marriage of Connolly. That one is from 1979. Likewise, for appeal, although the trial court's determination of the balance of harm for a preliminary injunction is reviewed on appeal for abuse of discretion, the trial court's interpretation of the statute is a matter of law reviewed de novo. See Department of Fish and Game v. Anderson Cottonwood Irrigation Distribution, 1992, and Thornton v. Carlson of 1992. Number 5, the judicial error rule. A judgment or order is presumed to be correct. Error must be affirmatively shown by the appellant. Denham v. Superior Court of 1970. Even where error is proven on appeal, a reversal is not automatic. The appellate court will reverse or modify only for prejudicial error as opposed to harmless error. Consequently, an appellant not only has the burden to prove error, but must also demonstrate that the error was prejudicial. Example, Seoul v. General Motors Corp. of 1994, erroneous refusal of proffered jury instruction, not automatically reversible error. Poole v. City of Oakland of 1986, defendant must prove instructional error caused prejudice. Prejudicial error rule. The prejudicial error rule is based on Article 6, Section 13 of the California Constitution, as well as statutes such as the Code of Civil Procedure 475 and Evidence Code 353 and 354. The most common judicial statement of the rule comes from People v. Watson, 1953, quoting portions of Article 6, Section 13. A miscarriage of justice should be declared only when the court, after an examination of the entire cause, including the evidence, is of the opinion that it is reasonably probable that a result more favorable to the appealing party would have been reached in the absence of the error. The test is necessarily based on reasonable probabilities rather than upon mere possibilities. Otherwise, the entire purpose of the constitutional provision would be defeated. What constitutes prejudicial as opposed to harmless error? What factors would an appellate court consider in determining whether it is reasonably probable that a trial judge or jury would have reached a result more favorable to the appealing party in the absence of error? Prejudice per se. Few types of error are considered reversible per se, such that prejudice is conclusively presumed and need not be proven. These include denial of the right to a jury trial, Shelby Constructors v. McCarthy. Denial of right to jury trial is reversible error per se without the need to demonstrate actual prejudice. Undue restriction of right to cross-examination, Fremont Indemnity Co. v. Workers' Compensation Appeals Board of 1984, erroneous sustaining of demur without leave to amend. Dexter v. Angus, 1986, failure to render a statement of decision when timely requested and required by CCP 632, Social Service Union v. County of Monterey, 1989, Miramar Hotel Co. v. Frank B. Hall and Company of 1985, and an award of punitive damages entered without evidence of the defendant's financial condition. See Adams of Murakami, 1991. 6. Stipulated reversals. Prior to 2000, an appellate court's power to reverse or vacate a trial court's judgment when the parties reach a stipulation as a condition of a proposed settlement of a pending appeal was governed by the judicial rules set forth in Neary v. Regents of the University of California in 1992. The Neary court had held that when the parties to an action agree to settle their dispute and as a part of their settlement stipulate to a reversal of the trial court judgment, the Court of Appeal should grant their request for a stipulated reversal absent a showing of extraordinary circumstances that warrant an exception to this general rule. The Neary court emphasized that this presumption in favor of stipulated reversal to effectuate settlement was strong and that the extraordinary circumstances exception was narrow. However, the judicial rule set forth in Neary has been superseded by the legislature. Effective January 1, 2000, CCP Section 128A8 was amended to read, an appellate court shall not reverse or vacate a duly entered judgment upon an agreement or stipulation of the parties unless the court finds both of the following. A, there is no possibility that the interests of the non-parties or the public will be adversely affected by the reversal. B, the reasons of the parties for requesting reversal outweigh the erosion of public trust that may result from the nullification of a judgment and the risk that the availability of stipulated reversal will reduce the incentive for pretrial settlement. The express purpose of amended CCP Section 128A8 was to overrule the Neary rule and to instead follow the federal court rule of stipulated reversal set forth in U.S. Bancorp v. Honor Mall Partnership. 1994. See Assembly Committee on Judiciary Analysis of Assembly Bill. In Bancorp, the U.S. Supreme Court held that in the absence of exceptional circumstances, settlement during appeal does not justify vacatur of the judgment under review. The court specifically ruled that the requisite exceptional circumstances do not include the mere fact that settlement provides for a vacatur. The court noted that judicial proceedings are valuable to the legal community as a whole and are not merely the property of private litigants and should stand unless the court concludes that the public interest would be served by a vacatur. The Bancorp court also rejected facilitation of settlement as a policy justification for stipulated vacatur. The next section will be extraordinary writs, as demonstrated in Omaha Indemnity Co. v. Superior Court. which will be followed by Save on Drugs, Inc. versus Superior Court. Before we reach notes and questions regarding extraordinary writs,